So in the time I've got available, I thought I'd go through these topics. I'll give you an update. So I'll sort of start from the end and work backwards, as it were. I'll tell you where we've got to since I last spoke a year ago. I'll talk a little bit about the nature of the bill, what it's designed to do, and then I'm going to focus in on some but not all, of the topics that the bill covers. About half the bill is to do with trade union rights, so I'm not going to bore you with that. I mean, a lot of that I don't understand, so it's a good reason not to talk about it, because I don't really understand it. But half of it's about trade union rights, the other half is about individual employment rights, I'm going to focus on. And I'm mindful, of course, that many of you, if not all of you, will be users of ambition services, so you'll use employment agencies, employment businesses. There's a specific take on a few of these provisions which are relevant to you as users and ambitions as a supplier. So I'm going to talk about zero hours contracts, which is probably the biggest concern for both end user clients and for agencies. The law relating to unfair dismissal is going to change a little bit as well. Statutory sick pay is going to change. That's with effect from April of next year, and that will be a big shift for this sector. I'm going to talk about something called fire and rehire. It's really misnamed. It's not really fire and rehire. It's about changing terms and conditions in people's contracts of employment, but it's been called fire and rehire because of the case that generated the changes. So I'll talk a little bit about that. Tribunal time limits are going to change. People are going to have longer to bring claims, which is good for them. Not too good for you because your nails will be shorter by the time you've bitten them. Some changes around umbrella companies. So a lot of agencies use umbrella companies to supply workers to end user clients. I'll talk a little bit about that. Some changes to family friendly provisions. And then a big shift is the creation of something called a Fair Work Agency, which is a sort of one-stop shop for enforcement. So it will replace the GLAA, it will replace or take on the functions of HMRC in relation to national minimum wage. It's a big shift, and it will have some fairly draconian powers. So I'll talk a little bit about that later. If we've got time, I'll talk about the law relating to harassment, and then questions and answers, or questions. I'm not sure I'll have many answers. Certainly questions and my best stab at answers towards the end. And lo and behold, it was delivered within 100 days. A bit silly, really. It was a rather daft deadline. I don't know why people get wound about doing things within the first 100 days. But we got it, and when we got it, it was a bit of a mess. It was about 140 pages. Some of the provisions really didn't make a great deal of sense. But the House of Commons took it in on the 10th of October, and since then it's been working its way through the parliamentary process. And I really am not one for hyperbole, but I've seen a previous employment rights bill, which then became the Employment Rights Act of 1996. And back in the day, we thought that was a game changer. Well, it was, but it's not on the same level as this. This is a once in a generational change to employment law protections. So it is a big move, a big shift towards protecting workers. And there are 28 areas of employment law that it covers. And as I say, we won't have time to go through all of those, neither would you want to go through all of them, but I'll pick off the main areas as I go through. Where we are now is that the bill has gone from the Commons to the Lords. The Lords made a number of proposed changes to it, which came back to the Commons, and the Commons has basically rejected all of them. And it's due to come back to, it's gone back to the Lords, it's due to come back to the Commons for a debate at the end of this month. And the word on the street is that once that debate's taken place, basically the Commons have said, Lords, get back in your box. We don't like your amendments. We're going to stick with the draft as it was. We don't think we'll get it. And the political commentators out there are saying we'll probably get royal assent just before the budget, because the Labour Party think this is good news. So we'll have a lot of good news. Look at how we're protecting workers, isn't it marvellous? We're going to give them all of these additional rights, lots more responsibilities for employers, and then a couple of days later we get the budget. So make of that what you will. So that's where we are in the process. There was a lot of commentary when Angela Rayner resigned, because she was the main protagonist behind the bill. It was her baby, as it were. And people thought that maybe the government's approach to the employment rights bill might change once Angela was out of the way. You might remember at the time there was quite a lot of stuff in the press where the unions kicked off a little bit and said, well, there's no reason why the Labour Party's approach to this should change, even though Angela Rayner's moved on. And we won't be very happy, by the way, if you do change your approach to it, because we like it the way it is. And they rolled out Peter Kyle into the spotlight in front of the cameras, and he made it very clear that there wouldn't be any change to it. It wouldn't be watered down as a result of Angela Rayner resigning. But interesting, because most of these I think are quite sensible. But nonetheless, the government have said no to them. So, the rejected amendments, one of them relates to unfair dismissal. You might remember if you were here last year, or you might remember because you've been reading about this in the last 12 months. The government's original proposal was to eliminate the qualifying period for unfair dismissal. So it's currently 2 years. So if you've got staff at the moment, they can only bring a claim for unfair dismissal if they've been continuously employed for 2 years. And the bill said that 2-year qualifying period is going to be abolished, so that people would be able to bring a claim for unfair dismissal from the minute they cross the threshold on the first day of their employment. The Lords thought that was a bit too draconian. Now, there's always been, for as long as I've been an employment lawyer, there's always been a qualification period. It started at 1 year, it went to 2 years, it went back to 1 year, and it's up at 2 years. It's been 2 years now for quite some time. So there's never been an unfair dismissal law without a qualifying period, or certainly it's a standard unfair dismissal. There are some types of unfair dismissal claim you can bring without a qualifying period. For example, if you claim you've been unfairly dismissed for maternity-related reasons, you don't need to have 2 years continuous service. But a standard unfair dismissal claim has always required a period of continuous service as qualification. So the Lords took the view that abolishing the qualifying period was probably the wrong way to go. So it suggested reducing the qualifying period to 6 months. I think that's quite sensible. But the House of Commons, when it considered that amendment, said no. And the reason they said no is because they've got a massive majority. It was in the Labour Party manifesto that they would abolish the qualifying period. So they've said no to that amendment. The government is sticking with unfair dismissal rights from day one. Guaranteed hours, I'll talk a little bit about this in the context of 0 hours, but if you're a 0 hours contract worker, you're going to get the right to receive an offer of a guaranteed hours contract after a period of time. The Lords took the view that rather than it being an obligation on someone to offer a guaranteed hours contract, it would be better if the right was a right to request one. So instead of the employer offering it, being under obligation to offer it, instead the worker would have a right to request one if they wanted it. The Lords thought that was sensible. I think that's sensible. The government have said no. We're going to stick with the original plan, which is that the employer will have an obligation to offer it. Yeah. So we're stuck with the original proposal despite the Lords thinking that was probably not the way to go. I'll talk a little bit about this, by the way, when I talk about 0 hours contracts. But within that same topic of 0 hours contracts, as well as having the right to be offered a guaranteed hours contract after a qualifying period, there are going to be some provisions around receiving reasonable notice about a shift being cancelled or a shift being modified. So if someone gets a call, for example, to go to work on a shift that starts at 9 o'clock, they get the call at 8:30, they turn up at 9, and for some reason that shift isn't available, there will be some rights to compensation in those circumstances, because the government take the view that those workers are being exploited. You can take a view on that one way or the other, but the suggestion from the Lords was that the period of notice to be reasonable should be at least 48 hours. And again, I thought that was sensible to have it fixed in time. The government have said no, it will be reasonable notice. Your next question is, what's reasonable notice? My answer is, I haven't got the foggiest idea, because it's not defined, and it will probably be dependent on the industry sector that you're working within. So let's say, for example, an IT contractor is going to go on a 6-month project with a client. Reasonable notice for that is probably going to be longer than it would be if you were someone going in to a field to pick strawberries. Yeah, reasonable notice is probably going to be longer for the IT contractor than it would be for the person going into a field picking strawberries. So the government is sticking with that, while I'm not losing any sleep over that, because every time someone queries what reasonable notice is, there's going to be an employment tribunal claim. I'm quite happy about it. It'll push back my retirement, I suspect, by 2 or 3 years, which is not so good for Tom, but it's great for me. So, reasonable notice on that. And there were some changes that the Lords suggested to whistleblower protections, too complicated to go into now, but pretty much the Lords have said there should be some further protections built in for the employer if someone blows the whistle on unlawful behaviour in the workplace. The government have basically said no, the employer's already got enough protection, so we're not going to add in any more, and they've rejected the Lord's amendments. The question is, well, when this when this bill becomes law, is everything going to come in at once? Or are we going to have staged implementation? I mean, the fashion for the last few years has always been with big bills. It's been staged implementation, so things happening over a period of time. So after a bit of ear bending, the government published a roadmap a couple of months ago and said, right, okay, when this bill becomes law, these are the broad timeframes that we're working to for certain of the provisions. So let's assume it's law by the end of the year, which we're pretty confident it will be. The first implementation is going to be in or around April of 2026. And this is not a comprehensive list, by the way, these are just the main items. There are going to be some changes to collective redundancy protective awards. Again, too much detail for today, but the maximum period is going to be doubled in those cases. That's with effect from April 2026. The Fair Work Agency, which I've talked about, that's going to be created in April of 2026. Doesn't mean to say it will necessarily be up and running and effective from April 2026, but it will be created as an entity from April of 2026. And then the big one for you guys is Statutory Sick Pay. I'm going to talk a bit about Statutory Sick Pay, but changes to that will be effective as from April of next year. From April, we then jump to October. October 2026, the government have said that they're proposing to extend employment tribunal time limits, and the law relating to fire and rehire, which, as I've said, is misnamed. It's not really fire and rehire. It's the law related to changes to people's terms and conditions of employment. That will be effective from October 2026. And then 2027, and bear in mind in 2027 we're only going to be 18 months or so away from a general election. So this huge thing that was promised last year before the election as being the greatest thing since sliced bread for workers, a lot of the big protections you'll see in that list are going to be deferred until 2027. Some commentators are even now saying that some of these might not see the light of day before the election. That's not what the government is saying, of course. They're saying that we're absolutely committed to bring in all of these changes. Umbrella companies are going to be regulated from 2027. There are going to be more changes to collective redundancy law. Flexible working changes will be made in 2027. The piece I've just mentioned to you about 0 hours contracts, guaranteed hours, compensation for cancelled shifts or modified shifts, that's been pushed back to 2027 because the government has recognised that in the recruitment sector in particular there might have to be a slightly different way of looking at it. There's been a lot of lobbying from the trade bodies like the REC, APSCO team, ALP. They've lobbied the government to say the law as it's currently drawn doesn't work for agency workers. So you might just need to rethink it. And the government have listened to that and said, okay, we recognise it might be a slightly different approach for agency workers, so we'll consult over it before we decide exactly what the 0 hours provisions will look like. And I think that's why it's been pushed back to 2027, because they want time to think about it and garner some responses. And then the big one there at the bottom, you'll see the day one right to bring an unfair dismissal claim, that's going to be 2027. Yeah. Now, I wouldn't want you to sort of sit back, fold your arms and think, oh, we've got loads of time, Paul, what are we worried about? Well, bear in mind that it's been a blink of an eye since I was stood in front of you this time last year. It will be 2 blinks of an eye before we get to 2027. So this will be on us before we know it. And I think if you sit back and wait and don't at least start to think about it and possibly even start to prepare for it, you could be left exposed. And that's why sessions like this are good, so that you can think about it, have a chat internally and get to grips with some of the issues. I did have a client who called me yesterday in a bit of a panic saying, do we need to change our terms and conditions, Paul? Do we need to change our contracts of employment? Send them through to you tomorrow when you have a look at them and then come back to me. And I just said, well, you know, hold on a minute, Rob. None of what you're asking me to look at it's not even law yet. So it might change, I don't think it will change. But what you're asking me to look at is something that will only be effective, we think, from 2027. So yeah, great that you want me to have a chat with you about it, but I think you're wasting your money currently making changes when the Act isn't even on the statute book. But I'm all for chatting, I'm all for discussing and working out what it might look like. So again, I think I said this last year, Angela Rayner said before the election that she was going to ban 0 hours contracts. Then she thought about it and decided that probably wasn't such a good idea, because lots of people in the economy work on 0 hours contracts. Lots of direct employees work on 0 hours contracts. Virtually the whole of the UK's agency workforce work on a 0 hours contract. So when she realised that banning them would probably not be such a good idea, she modified her position slightly on it and said, okay, we're not going to ban them, but what we're going to do is we're going to ban the exploitative ones. And that's still the government's stated policy, that they're going to ban exploitative 0 hours contracts. The problem with that is no one's ever defined what an exploitative 0 hours contract is. If you ask people, they say they don't really know what an exploitative 0 hours contract is. And none of what I'm about to tell you results in them being banned. So we've sort of come full circle. We're going to ban 0 hours contracts completely. Oh, no, sorry, we're not going to ban 0 hours contracts. We're just going to ban the exploitative ones. And when I tell you what they're actually going to do, you'll see that they're not banning anything at all. What they're doing is they're making it more difficult for the long-term use of 0 hours contracts. That's it. They're not banning them. They're just making it more difficult to use them on a long-term basis. So the first thing they're doing, and I've mentioned this already, is that after a qualifying period, if you're a worker on a 0 hours contract, after a qualifying period, you'll be entitled to be offered a guaranteed hours contract. So the qualifying period at the moment looks as though it's going to be 12 weeks. So any of you familiar with the agency workers regulations, same qualifying period for agency workers regulations rights. 12 weeks, a worker has been working on a 0 hours contract. At the end of that qualifying period, the relevant employer, and I'll talk to you about who that is in a moment or two, the relevant employer will be under an obligation to offer them a guaranteed hours contract. And the guaranteed hours contract will be calculated by reference to the hours they've worked over that 12-week period. So you'll add up all the hours they've worked over 12 weeks, divide by 12, that's the guaranteed hours contract that they're entitled to. You can offer them more than the guaranteed hours, of course you can if you want to, but you can't offer them less than the guaranteed hours. Now that sounds pretty draconian. I think it's certainly draconian on one level, because if you think about it in the context of an agency supply, the agency's got the employment relationship with the worker whilst it's supplying them as a temp. After the 12-week qualifying period, the end user, the client, is under an obligation to offer a guaranteed hours contract. Now if you're an end user client, you'll be using an agency worker for a reason. All sorts of reasons why you use agency workers. In my experience, it tends to be because it gives you the ability, it gives you a lot of flexibility. You can flex up and down, you can meet demand, you can push back when you don't need them. So it's a flexibility issue. These new provisions will eliminate that flexibility completely. You'll then be under an obligation to offer someone who you would never have wanted to offer a contract of employment to at all prior to these provisions. You'll be under an obligation to offer them a contract. And you wouldn't have done that before, you'd have just carried on using them as an agency worker. But the government doesn't like agency work, funnily enough, despite the fact that it likes flexibility. It doesn't like agency work, it doesn't regard it as proper work. I mean, these are 1960s, 1970s philosophical principles. They don't work in the 2020s. They just don't work. The Labour Party still thinks that you're only gainfully employed if you're working 40 hours a week, 5 days a week for the same employer. There's nothing else. That's sort of full employment, that's proper employment. And we all know that the real life is completely different to that. So first of all, you'll have a change in the employer. The employer before the guaranteed hours offer was the agency. The guaranteed hours offer is made by the end user client, so the employer changes. And the status of that worker changes. Most agency workers aren't employees of the agency, they're engaged on a contract for services. So they're not employees, they're workers. But they'll then become, if they accept this offer of a guaranteed hours contract, they'll then become an employee of the client. So it's interesting, it's government intervention, it's government forcing an employer to employ someone when they wouldn't want to ordinarily, which I think is crazy. But I think the silver lining in this rather large grey cloud is that if I know this sector as well as I think I know it, I think there'll be very few agency workers that say, yes, I will take you up on that offer of a guaranteed hours contract. Because in my experience, most agency workers still want the flexibility. And they'll lose the flexibility if they end up on a guaranteed hours contract with the client. So I think, even though it's an obligation, and an obligation you've got to discharge, if you don't discharge it, you'll be sued in the employment tribunal. But I think you'll be surprised as to how few agency workers take up the offer. That's my own view. I'll be interested to hear your views later. So that's the first approach they're taking to tackle what they say are exploitative 0 hours contracts. I mean, I don't see anything exploitative about that. That's just an ordinary 0 hours contract, which is being converted into something it wasn't meant to be in the first place, to the detriment of the employer, it seems to me. The second piece around 0 hours contracts, I can sort of understand why they think this is exploitative and why they want to do something about it. It's the half example I gave you earlier on. So the client rings the agency and says they've got a shift starting at 9 o'clock, can you send someone? They're ringing them, by the way, at 20 to 9. Yeah, so they're ringing them at 20 to 9. We want a worker in 20 minutes, please. So the agency gets on the blower to the worker, says, Mrs. Smith, can you go along to this shift at 9 o'clock at this client's premises? And she says, oh yeah, I fancy a bit of work today, I wouldn't mind doing that. But I've got 4 children and no childcare. And the client's premises are 60 miles away, so I'm going to have to get a train ticket, and that's going to cost me 70 quid. But yeah, I'm up for it, I'll do it. So she gets the kids into very expensive emergency childcare. She buys a £60 return train ticket. She gets there at 9:30, so she's missed the 9 o'clock start. And the shift supervisor says, oh, I'm sorry, did someone say it was 9 o'clock? No, it's 2:30 this afternoon. Or, no, it was 9 o'clock, but we filled it now because you are late. We've got someone else from a different agency. Or even worse, oh no, I'm really sorry, it wasn't today, it's next week. Yeah. So Mrs. Smith, poor old Mrs. Smith, I mean, you know, she's got the kids sorted out. She spent 60 quid on train tickets she didn't spend 60 quid on. She's been exploited, the government says. And I can sort of see why they would say that. That's not fair on Mrs. Smith, is it? It's just not fair. So Mrs. Smith, if she's hacked off about it, will be able to take both the agency and the end user hire potentially to tribunal and bring a claim for compensation. So the cost of the emergency childcare would be about £3,000, won't it? The £60 for the train ticket and any other out-of-pocket expenses or losses that she sustained as a result of being messed about. But she'll also be entitled to these statutory payments by virtue of the fact that she had a shift cancelled, or she was given late notice or not reasonable notice of that shift in the first place. So I've got a bit of sympathy with the problem the government are trying to fix here, because there is no doubt that workers do get pulled and pushed around like this. It's probably the exception rather than the rule, but they do suffer these sorts of situations. And the government have decided it's not appropriate. People shouldn't be treated like that. They're on a 0 hours contract. They should have some security if they're offered a shift. And they should be given reasonable notice of that shift. And if the shift's going to be cancelled, they should be given reasonable notice of the cancellation of it. Well, I've already said the responsibility for offering the guaranteed hours contract in an agency supply situation falls on the end hirer. So if you use agency workers now, you will be the one that has to make the guaranteed hours contract offer, not the agency. And that's a bit of a surprise, because when the government consulted over this, they gave 2 options in the consultation document. They said, should the responsibility for offering the guaranteed hours contract sit with the agency, or should it sit with the client? And most employment lawyers that I spoke to at the time said, oh, well, they're bound to find that the obligation should be on the agency, because the agency is already the employer. They can't possibly shift that responsibility to the end user client. But it's a good job they didn't put any money on it, isn't it? Because that's exactly what they did. They put the responsibility for offering that contract onto the end user hirer. The responsibility for providing reasonable notice of a shift, or reasonable notice of the cancellation of a shift, or curtailment or the modification of a shift, that's going to fall on both the agency and the hirer. So it's a sort of joint liability. But there'll be circumstances where it's clearly the end hirer's fault, and there'll be circumstances where it's clearly the agency's fault. There'll be some circumstances where it's 6 of one and half a dozen of the other. So I think that's the reason the government have said that's how they'll split the liability. So you could get a situation where a client calls the agency a week before the shift is due to start, says we'd like someone next Tuesday morning, please. And the agency overlooks that request and only calls the candidate on the morning of the following Tuesday. Clearly the responsibility there lies with the agency, doesn't it? The agency have made a mess. They should have got someone lined up a lot earlier. So I suspect a tribunal, if there's a claim, will find that the agency is responsible for that, and therefore the agency is on the hook for any compensation or curtailment payments, subject to the final point, which I'll come on to in a second. The end hirer, of course, could be responsible. So the end hirer might have known that they needed someone next Tuesday, but they only call the agency 20 minutes before the shift's due to start next Tuesday for the worker. The agency moves on that really quickly and gets someone lined up. So in those circumstances, it seems to me that tribunal is likely to find the end hirer is responsible rather than the agency. So again, there's going to be some litigation, he says, rubbing his hands with glee. Around that point, who's responsible, agency or hirer or both? And then this scheme for making penalty payments, I'm calling them penalty payments because that's effectively what they are. They're not compensation payments. You don't actually have to have lost any money to get these curtailment payments. They're penalties. The responsibility to pay the short notice cancellation of curtailment payments, sorry to say, sits with the agency. But the agency's got to make those payments. The compensation split. So for the compensation payment to be paid, that sits between the agency and the hirer as a result of that second bullet point. But the penalty payments, which are different, they're not compensation payments, they're just penalties, they'll sit with the agency. But the silver lining for the agency, you can see, is that they'll be able to put a clause in their contract with you, the end user, to say if they have to pay these out, you'll reimburse them. 0 hours contracts. That's a really whistle-stop tour through 0 hours contracts, but I hope what you glean from it is nothing's been banned, there are just 2 new protections, and then there's a bit of a mess in place around who's responsible for paying what. It's a bit of a mess. And I don't think any of this needs to change, frankly. I think it works pretty well as it is. But there you have it. That's the unions for you. That's the only political comment I'm making this morning. That's the unions. This is all union driven, as you might imagine. So unfair dismissal. The current rule is that if you want to bring a standard unfair dismissal claim, you've got to have 2 years continuous service with the same employer. There are some exceptions to that. I mentioned one already. If you are dismissed for pregnancy-related reasons, then you can bring a claim without 2 years service. But most of the claims require 2 years qualifying service. As I've said already, the Lords had a look at it and thought, abolishing that, it's a bit draconian. Maybe we stage it, we go to 6 months first, and then after a while, if that's not working, we can move to 0. And the Commons have said, no, we're going to stick with it as it was. It was a manifesto commitment. So the minute someone crosses your threshold on day 1, if you sack them, they can bring a claim for unfair dismissal. They can't do that at the moment. They need to be with you for 2 years. So that's quite a big change, isn't it? It's quite a big change. It's going to modify the way you behave towards new employees, that's for certain. And effectively, that's what the Labour Party is saying, to be fair to them. They're saying it will lift the standard of employee relations. It will mean that everybody's treated fairly, instead of this sort of qualification apartheid, where people over 2 years get lots of lovely protections and are treated really nicely because you're frightened to death of a claim. Whereas anybody with less than 2 years service, you throw them on the scrap heap at the drop of a hat, because you're not bothered about the claim. That's effectively that's the rationale behind all of it. But the government's ear was bent, and they did listen to very, very concerned employers when this was published late last year, because most employers have said this is really problematic. You know, this is going to increase our cost, and it might even result in us not employing people, or not employing as many people as we might otherwise have employed. And if you couple that with things like national insurance increases and all the rest of it, I think this has the potential to be an anti-growth measure rather than a growth measure. And they keep telling us that they want growth. There's not much in this bill, it seems to me, that's promoting growth, but look, that's just my take on it. But they've listened and they've come up with this sort of half-baked statutory probationary period concept. And it's very keen, it's very important that you understand that this is not a qualification period by the back door. So I want to explain it. This is not a hidden qualification period. the starting point is everybody will have the right to bring a claim for unfair dismissal from day one. The statutory probationary period, which we think will be 6 or 9 months, more likely 9 than 6, everybody who starts for the first 9 months, it will be easier, I don't know how much easier for you to dismiss them fairly in that first 9-month period than it would otherwise have been. So that's why I'm saying to you, it's not a qualification period by the back door. They don't have to work for 9 months before they can bring a claim for unfair dismissal. They can bring the claim, it's just that the regime will make it a bit easier for you to sack them fairly in that first 9 months than might otherwise have been the case. But we don't know what that looks like yet because there's going to be some consultation around it. I suspect it's going to be really, really complicated, which of course is great news for me, not very good news for you because you've got to deal with it on the ground. So we're waiting to see what that looks like. But it could be a dog's breakfast. And the other bit that they've listened to employers about this. You see this final bullet point. What they're also saying is that if anybody's dismissed during the statutory probation period and they're successful in bringing an unfair dismissal claim, the government will reduce the statutory cap. So at the moment, you know, if anybody brings an unfair dismissal claim, they can get a maximum of a year's pay, or about £110,000, whichever is the lower amount. So if they pay £200,000 a year, it'll be capped at about 110. If they pay £75,000 a year, it'll be capped at 75,000. That's the way it operates. So what they're proposing is that anybody dismissed unfairly in the statutory probationary period, the cap will come down. So again, it's designed to be a bit of a disincentive in a sense. So no backdoor qualification period, just a little bit easier to dismiss fairly, and possibly a reduction in the statutory cap for compensation if someone brings a claim. But this is huge. This is really huge. And you know, you may think you've got a decent-sized HR team already. How much bigger is your HR team going to have to be when all of your less than 2 years service people have got this protection? Because there'll need to be advice given about whether the dismissal is fair or unfair, what process you've got to go through, and you don't have to bother about that at the moment. At the moment, all you have to ask yourself is, has someone got a protected characteristic under the Equality Act? Because if they have, they could bring a discrimination claim with no service at all. But if there's no protected characteristic, you can pretty much sack for whatever reason you like within that first 2 years without any liability. That will all disappear. That sort of laissez-faire approach is going to completely go on these new provisions. You're going to have to think very carefully about every single person that you want to sack from the minute they walk over your threshold on the first day. So the Labour Party jumped up and down around COVID because lots of people fell outside the statutory sick pay regime. And they thought it was very, very unfair. There are 1.3 million people at the moment who earn less than the lower earnings limit. And as the law currently stands, if you earn less than the lower earnings limit, you're not entitled to statutory sick pay, which I think is bizarre. Wouldn't you have thought that statutory sick pay should be given to those people who earn the least? But it doesn't work like that, and it never has worked like that. Anybody earning less than the lower earnings limit currently doesn't get statutory sick pay. So the first change from April of next year is the lower earnings limit is going to be abolished effectively. So everybody under the lower earnings limit will then come into scope for statutory sick pay purposes. So that's another 1.3 million people who will take Mondays off after they went to the pub on Sunday afternoon. Yeah? But at the moment, if they take Mondays off after having gone to the pub on Sunday afternoon, they don't get statutory sick pay because that's the first of 3 waiting days. And you only pay statutory sick pay from day 4 of absence. That's great. The guy that goes to the pub on Sunday afternoon doesn't turn up on Monday morning. He doesn't get paid statutory sick pay. because he has to be off for another couple of days before he gets entitled to it. That qualifying requirement is going to go as well from April. So instead of you only getting statutory sick pay from day 4, you will get it from day 1. So 1.3 million people in scope, and every single one of those people and everybody else who's already entitled to it will get SSP from day 1. I think that's huge, and it's very expensive. For those of you who operate contractual sick pay, this doesn't really impact you. You'll carry on paying your contractual sick pay payments in any event. You've probably got a clause in your contract of employment that says any obligation to pay contractual sick pay also discharges your obligation to pay statutory sick pay. So in other words, the SSP amount is within the contractual payment. So in that sense, it does impact on you. But it doesn't directly increase the cost to those of you who have a contractual sick pay scheme in place. This will affect people who don't have contractual sick pay schemes in place and only pay SSP. This will increase their cost base quite significantly, it seems to me. And I might be an old sceptic, but I think more people might take a day off. This is fire and rehire. It's not fire and rehire. I don't know why people still call it fire and rehire, but it comes from a case a few years ago. You might remember P&O ferries. Big hoo-ha about P&O ferries. One day they sacked all of their P&O ferry staff, and then they recruited a load of agency workers to come and work in their jobs, because the P&O ferry staff were offered a new contract on reduced terms. So we were paying you £40,000 yesterday. Tomorrow we're going to pay you £25,000. No, I don't want that. I'd like to carry on being paid £40,000. Oh, sorry, if you don't accept the £25,000, we're going to sack you. Well, we're not taking 25, well, okay, you're sacked. Yeah. And what we'll do is we'll bring in all these lovely Filipino agency workers who are going to do your jobs for you. That'll be a lot cheaper for us. So thank you very much, off you go. And the trade union jumped up and down about it. As it happens, the Tory government jumped up and down about it a bit, and the Labour Party were absolutely livid. So they said, when we come in, we're going to change the law. That can't happen again. And what they've done is they've actually gone a lot further than that case. They've made it, or they will make it when the bill becomes law, they'll make it very, very difficult indeed to lawfully sack someone for refusing a contractual variation to their contract. I've got another slide which will just explain the difference, because there's been a slight modification of the government's position again as a result of employer lobbying. But what the bill effectively says is it will be automatically unfair to dismiss someone if they refuse a contract variation. So in that example I just gave with the P&O people, £40,000 yesterday, £25,000 tomorrow. No, I don't want that. You're sacked. Under these provisions, that will be an automatically unfair dismissal. And it currently isn't an automatically unfair dismissal. It might be an unfair dismissal, but the individual's got to prove that it was unfair. Once it becomes automatically unfair, they really don't have to prove anything other than that's the reason they were dismissed, for refusing a contractual variation. And there is only one limited exception. Because if you remember back to the P&O case, the P&O ferry case, the company said, we're doing this because if we don't do it, we're going to be out of business next week. This is so expensive that if we don't reduce our pay, we're going to go out of business. And that's the one limited exception that the government have allowed. If the employer is experiencing severe financial difficulty and is about to collapse, which is making firing and rehiring crucial to the survival of the business, that will give you a defence to one of these automatically unfair dismissal claims. But it's going to be very difficult to prove that. And it will be a little bit more than just the HR manager sitting in the witness box in the tribunal saying, yes, if we didn't do this, we would have had to sack everybody because the business would have gone under. The judge is going to want to see figures, accounts, management accounts, cash flow forecasts, probably even expert evidence from an accountant who will say, yes, I can say that if this hadn't happened, the business would have gone under. It's going to be quite difficult to prove, it seems to me. So if anybody's thinking, oh, that's not a problem, we could just roll out a defence, I don't think it's going to be an easy defence to prove. So again, quite a big change. But what we've done here is just put an extra slide in because the government have changed their approach ever so slightly. And what they're saying is it won't be any old term that's varied, the refusal of which gives rise to an automatically unfair dismissal. We're going to put them in two categories: serious terms and not so serious ones. And it's only the serious ones that will result in an automatically unfair dismissal. The less serious ones where you can do it and you're subject to the normal rules. So the ones that are restricted, surprise, surprise, money, anything in the contract to do with pay, benefits, bonuses, holiday pay, pensions, that will be classed as a money term. Any variation to that and a refusal to accept it followed by a dismissal will mean the dismissal is automatically unfair. Time, so saying to someone, when you currently we currently want you to work 40 hours a week, with effect from next week we only want you to work 25 hours a week. That's pretty important. The chances are their pay will go down as well. So anything to do with time, changes to hours, shifts, holiday allowances, time off in lieu, anything to do with time will also be an important term. So if someone's dismissed for refusing to accept a change, that will be an automatically unfair dismissal. And there's going to be, we don't quite know very much about this last item on the left-hand side, but there are contracts with flexibility clauses in. You may have one yourself, or your organisation may have one. It's a little throwaway line at the end of the contract that says we can basically change any of these terms when we like it. Yeah. They're a bit difficult. They're a bit difficult to enforce. So we get asked questions about flexibility clauses all the time, and they're not the sort of golden ticket. They're heavily restricted in terms of how the tribunals allow you to use them. But basically what the government is saying is that if there's an abuse of a flexibility clause like that, that will be a serious breach. And therefore the dismissal will be automatically unfair if someone says, no, I don't like that change. But we need a bit more meat on that bone at the moment, so I can't give you any more on that. They've just said that abusing flexibility clauses will be potentially on the left-hand side of the line, which will be a clear automatic unfair dismissal. And I'd like to be able to say to you that everything on the right will definitely not be an automatic unfair dismissal, but I can't give you that guarantee. The government is saying at the moment that the jury's still out. But what they're saying is that these changes might be lawful. They're not saying they definitely will be, they're just saying they might be. So we'll need to see some more meat on that bone as the legislation hits the statute books. But what may be a potentially lawful change is a change around your role or your job description and duties, location, where you work, whether there's a mobility clause in your contract, whether you're allowed to work from home or not work from home. Anything to do with location would probably be legitimate in terms of you changing the contract. And exit provisions, that should say restrictive, we're going to throw them restricted covenants. But any terms in your contract relating to notice or restrictive covenants, if you want to change those, and someone says no and then you dismiss them, that might not be an automatic unfair dismissal. Time limits. So at the moment, if you want to bring a claim for unfair dismissal, for example, you've got to bring the claim within 3 months of the effective date of termination of your employment. most tribunal claims have a 3-month time limit. Not all of them. Some of them have longer. If you want to bring a claim for a statutory redundancy payment, for example, you've got 6 months from the date you were dismissed for redundancy reasons to bring a claim for a statutory redundancy payment. And the 3-month period that's the standard limitation can be extended, most of you will know, I suspect, because there's an ACAS pre-claim conciliation process that has to be gone through before a claim can start. And depending on when you start the ACAS pre-claim conciliation process, you can add a month to the limitation. So that 3 months can become 4 months in certain circumstances. But the primary period is 3 months. The government thinks that's not long enough. Because there are lots of people who don't bring claims, who have claims, who could bring claims, because they just missed the 3-month point. So they're going to give them an extra 3 months to think about it, which is an extra 3 months for you to bite your nails. Because at the moment, clients are ringing and saying, well, it's been 3.5 months, we've not had a tribunal claim. Do you think we're out of the woods? Well, if you'd asked me that 2 years ago, I would have said pretty much you're out of the woods. The problem is now tribunals are taking 12 to 15 weeks to process claims. So there might be a claim lodged, but you won't know about it until almost 4 months later. So it's all a bit of a dog's breakfast really at the moment, the tribunal system. But the point is, you won't be able to get a claim struck out now on the basis that it was brought outside the 3-month limitation period. You'll only be able to bring it to get a claim struck out if the claim was brought outside the 6-month limitation period. So it's going to increase the cost of managing tribunal claims. More employees, I think, are going to bring claims now. You know, the ones that were, well, I'm not sure, and then the 3-month clock ticks over, and then they say, well, damn, I wish I brought one. Well, now they don't have to worry about the 3-month clock ticking over. They've got another 3 months to prevaricate before they get the claim in. So will there be more claims? I think there will be more claims. And the government's own numbers, bear in mind these are the government's own numbers, so the numbers are probably significantly worse than this. They estimate the cost will be 13.6 million, the direct cost of this, with a 5% increase in cases. I think that is really conservative, 5%. I think a lot more than 5%. And whilst I'm on this slide very quickly, you might have heard in the press, maybe last week, some suggestion that the government were thinking of reintroducing tribunal fees. A standard flat rate £55 for everybody who wants to bring a claim. And you might remember years ago there was another scheme which was ultimately struck down by the Supreme Court as being unlawful. So the government had to refund all of this money that people had paid to bring claims. So if the story was true, we weren't going back to that, because that was something like £250 to lodge a claim, and then further payments as the claim progressed through to a tribunal hearing. This was just going to be a one-off fee if the story was correct. West Streeting has now gone to the press and said it's nonsense. We're not introducing tribunal fees. So it must have been discussed, but they decided not to introduce tribunal fees. Again, I suspect because the unions have said we don't want you to introduce tribunal fees. It's not a good idea. So tribunals will still be free, and the costs regime will stay the same. So if you bring a claim and you win, whether you're a respondent or a claimant, you probably won't get any of your legal fees paid by the losing party, which is the current regime, and that's why 98% of them form the tribunal claim. There are 700,000 umbrella workers at the moment in the UK and about 500 umbrella companies. Currently, they're not regulated in the same way as employment agencies and employment businesses are, so ambitions are regulated by the Employment Agencies Act and the conduct regulations, as well as a whole host of other bits and bobs that they've got to comply with. Umbrellas are not and never have been. And the government have taken the view that's not a level playing field. Umbrellas, they say, should be regulated, and umbrellas will be regulated with effect from 2027. They'll be brought within the definition of an employment business for the purposes of the Employment Agencies Act and the conduct regulations. That will only happen after consultation, which is why it's been pushed back to 2027. The other bit that's not on the slide, which I'll mention, is that with effect from April of next year, nothing whatsoever to do with employment rights bill, by the way, this is just a separate Treasury measure. Umbrella companies and agencies will be jointly and severally liable for any failure to pay the revenue of tax and national insurance contributions on an agency worker or an umbrella worker's pay. If you use an umbrella worker, the umbrella company employs the worker and pays the tax and NICs. But some unscrupulous umbrella companies are paid by the agency and then they run off with the money that they should have paid through HMRC for tax and NICs, which means HMRC have got nowhere to go because that company's normally dissolved, disappeared, or they've gone to Mauritius for a very long holiday. So in order to plug that gap of unscrupulous umbrellas running off with money that they should have paid to the revenue, the agency is going to be on the hook. So if they can't get the money back, if the revenue can't get the money back from the umbrella, they can get it from the agency. So agencies using umbrellas now are going to be very careful about the nature and the identity of the umbrella company that they use. That's a separate provision to this. That's a Treasury change, but that's with effect from April of next year, not 2027. The bill establishes an entitlement to bereavement leave as a day one right. Currently it's not a day one right, there's a qualifying period. Paternity leave and unpaid parental leave, there's currently a requirement for 26 weeks service. That will go, that will be a day one right. There'll be changes to flexible working. Interesting this, isn't it? They're going to make all those changes to the use of zero-hours contracts to make it harder for zero-hours contracts to continue, yet they're going to increase rights around flexible working. I don't understand it. It's almost left hand not knowing what right hand is doing. So new measures to support access to flexible working. They're going to make it more difficult for employers to turn down a flexible working request. And the information requirements are going to be tougher. So instead of you just saying to a worker, no, because, you're going to have to jump through a few more hurdles to justify your position as to why you've turned down that flexible working request. So again, I can't give you much more meat on that bone because this is going to be subject to consultation moving forward. We'll just be ready for that. It's going to be a lot easier for people to request and a lot harder for you to turn down flexible working. Fair Work Agency, very quickly. A new central enforcement body, as I've mentioned, it unifies the existing disparate functions. And it's designed to support compliant employers and to help aggrieved workers enforce their rights. Those are the powers that they will have. I think this is a great idea, but only as good as the resources the government put into it. If the government give the Fair Work Agency no money, this will be a total and utter waste of time. If they give them proper resources, staff, it will be a great idea because it'll bring everything together. The one that jumps off the page for me is this one. The Fair Work Agency can bring tribunal proceedings on behalf of workers. Even on behalf of workers who don't want employment tribunal proceedings to be brought in their name. Wow. It smells of East Germany, this, doesn't it? So Mrs. Smith has not had her holiday paid correctly. And she goes to the Fair Work Agency, she says, I'm not my holiday paid correctly. And the Fair Work Agency makes a few investigations and realises that there are another 60 people at her employer that haven't been paid their holiday pay correctly. So they say to Mrs. Smith, well, you can bring a claim. She says, no, I don't want to. Maybe I'll write them a letter and ask them if they'll pay me, and if they won't, well, I'll just put it down to experience. The Fair Work Agency will then say to Mrs. Smith, we'll bring it on your behalf. She says, no, I don't want you to do that. It's going to cause all sorts of problems if you bring. We're going to do it because there are another 60 people over here who've been treated exactly the same way as you, and our job is to ensure that rights are enforced. So poor old Mrs. Smith then has a tribunal claim brought in her name when she never wanted one. I mean, she might get some money out of it, but that's not the point, is it? She's had a claim brought when she didn't want the claim to be brought in the first place. So I think it depends on your political point of view, doesn't it? That's either a great thing, because it means that the Fair Work Agency can go off and get employers in line, or it's a really bad thing for individual rights, isn't it? trampling over Mrs. Smith's desire not to bring a claim. I'm not entirely convinced that's right. So we've got the GLAA, Gang Master and Labour Abuse Authority powers, which will go into the Fair Work Agency. The scope of Margaret Beale, who's the Director of Labour Market Enforcement, at the moment, Margaret Beale, sorry, she's the Director of Labour Market Enforcement. Her role will go and her functions will go into the Fair Work Agency, and the HMRC's enforcement powers around national minimum wage. They enforce national minimum wage, don't they, at the moment. Their functions will go into the Fair Work Agency. So for this one-stop enforcement body that will deal with all of those issues. I think I may have mentioned it. You as an employer have an obligation to take reasonable steps to prevent sexual harassment in the workplace, which was a change. Prior to that change, you didn't have any obligation to take reasonable steps to prevent harassment in the workplace. This bill changes the law again. This bill requires you to take all reasonable steps. It's only a 3-letter word, but it makes a massive difference. Because currently, you can persuade an employment judge that you took reasonable steps. You might not have taken every possible reasonable step available to you, but that will give you a defence to a claim. Under the new rules, you've got to take all reasonable steps. So if the tribunal judge says, done 9, what about this 10th one that I think you should have taken that was reasonable and you've not taken it? Oh, we didn't take it. Right, you're liable. So that's a huge change. You're going to have to think about due diligence in your supply chain, because this applies to third parties. So if you have some scaffolders who come up, I think I used this example last year, didn't I? Very well, because I said something that was politically incorrect. You have some scaffolders who come in and start hurling abuse at some female employees as they walk into the office. You'll be on the hook for their harassment of your employees, even though you're not their employer. Unless you can show you took all reasonable steps to prevent the harassment. I'm not sure in that situation I know what all reasonable steps are to prevent a guy on some scaffolding shouting some sexual abuse to a female employee walking into your office. Any suggestions? No, I don't know. But if you've not taken these difficult to fathom all reasonable steps, you'll be liable. So, just to wrap up, I usually am criticised for not delivering good news. I make no exception today, because I haven't delivered any good news. This is all bad. This is all really bad if you employ people. It's really bad. It's great for employees, but it's really bad if you employ people. What I'd say is, and I did put a LinkedIn post up about this a few weeks ago, because it wells up inside you for months, and you see all this nonsense being spouted on LinkedIn about what all these new rules are about. It's all rubbish. And the problem is, people ring me and say, I read this on LinkedIn. I say, it's rubbish. And I say to them, just be careful where you get your information from. There is a lot of nonsense about the Employment Rights Bill. I mean, real nonsense. So I said I wasn't going to sell. I'm not selling, really. I don't care where you get your professional advice from. It'd be nice if you got it from me. But if you don't want to get it from me, just take it to somebody who knows what they're talking about. Because if you get this wrong, it will be problematic for you. It will cost a lot of money. We're not there yet, so I gave you the example of the client who rang me yesterday to say, should we change our terms? No, it's a bit early to change your terms, but do start thinking about what those terms might have to look like moving forward, because it's not even an act of parliament yet, let alone have we seen any of the regulations, the secondary legislation that's going to be necessary to bring some of this into force. And that could change things quite significantly. But there's no doubt you're going to be incurring significant additional cost. I think you're going to have more people off sick. You're going to have all sorts of claims in the employment tribunal. You may want to think about taking out some insurance cover for those claims. There is insurance cover available if you've not thought about that. And as a lawyer, well, yeah, we've certainly moved on. I'm in a better position here 12 months on than I was 12 months ago. I was giving you really bare bones last year. There's a lot more now that we know about all of this, but there's still a lot we don't know. So we do need some clarity. So keep your eyes peeled for the consultations. You know, if you're in a particular sector and the consultation involves you, I would strongly recommend you do put a response in. You know, they are read, they are taken into account. Do prepare to audit your contracts and your policies. And I don't think you're going to be able to avoid training people who have a direct interface with employees, line managers, people who are on the ground working with employees, not the MD, the CEO, the HR director. Yes, they'll need to know all about it as well, but the problems will stem on the ground. So it's important people are trained, even if it's just about the bare bones, not necessarily the detail, just that they know what this new environment looks like. So you need to think about, I think you need to think about training those staff members.